I brought you.
Off on the right foot. Okay. All right. Again, hello, everyone. Thank you so much for joining us today. Welcome to today's CLE presentation by John A. Birmingham Jr. Esquire on the topic of Part 2 of Roe versus Wade and 49 Years Later. My name is Elena Taylor, and I am the Dallas Area Paralegal Association's Medical and PI and Real Estate Section Chair. And I'm joined today by Mr. Birmingham. We appreciate you taking the time to attend during your lunch hour. I'm also joined by Veronica Redman, one of our education director. Here are some announcements and housekeeping information. Please visit our website at dallasparalegals.org to check the event calendar and register for any upcoming presentations, as well as the general membership meeting. For best practices, can you please enter your full name on the Zoom screen so that we can confirm who is attending the meeting? This acts as our sign-in sheet for Zoom and our checks and balances to help verify attendance. This will be an interactive session, so feel free to post your questions or comments in the chat room and we will monitor those. And towards the end of the CLE, a passcode will be issued. If you would like to receive a certificate for this presentation, please send a request via email to myself, etaylor@foxrothschild.com, along with the passcode, and a CLE form will be sent to you. Thanks again for joining us today. I would like to present our speaker, John A. Birmingham. Mr. Birmingham.
Great. Well, thank you so much. And it's good to be back. Good to see everyone again. And yes, this is a continuation.
We lost audio, Mr. Birmingham.
I'm sorry. Can you all hear?
Do I come in better through the computer?
Probably turn your volume down. If you can turn your volume down.
Okay.
How is that? Is that good?
I'm hearing an echo.
And right now they're saying yes, they can hear you. I'm just not sure whether I have my phone next to the computer, so maybe they're still hearing you through the phone.
Yeah, my computer's muted.
Yeah, that echo is caused by
maybe the phone is echoing.
It could be.
Yeah, it's echoing because you're probably
they said there's an
location.
Yes.
Yeah, maybe mute your cell phone.
Okay. Let's try it that way. Okay.
Check 1, 2. Is the echo gone?
The echo is still there.
Here?
Okay. I think we're good to go. I don't see otherwise. So just let me know if it's tough to hear me or if I need to sign out and sign back in. But let's continue to where we left off last presentation. So basically we talked in the first half of this about the court opinion being leaked, what that meant for the justices, and how Dobbs basically overruled Roe v. Wade. And here was the ruling from the Supreme Court, and this is June of last year. The Supreme Court came back in the ruling of Dobbs v. Jackson Women's Health Organization and said the Constitution does not confer a right to abortion. Therefore, Roe and Casey are overruled, and the authority to regulate abortion is returned to the people and their elected representatives. So the Supreme Court gave it back to the states and said, states, you guys go decide what kind of restrictions you're going to have on abortion, or if you're not going to have any restrictions at all. And the main question the Supreme Court had to look at is whether the Constitution really was properly understood in Roe v. Wade, as was confirmed by the Casey case. and whether the Constitution, somewhere in the Constitution, actually gives women the right to an abortion. Casey's ruling basically skipped over that question, reaffirmed Roe under the concept of stare decisis, which means let the decision stand. Supreme Court said is when you go over and review a case, and if you're doing it based on case law precedent, you have to go back and look and see if the case, the precedent case, was actually ruled upon the correct way. This was done in Brown v. Board of Education, where Plessy v. Ferguson, which was decided in the late 1800s, said separate but equal is constitutional, that you can have a train car for African Americans, you can have a train car for Caucasians, you can separate the races, and as long as both train cars are equally situated and maintained the same way, separate but equal is constitutional. Brown v. Board of Education, the Supreme Court was told that you have to apply Plessy v. Ferguson. That's case law precedent. So you could have separate train cars and you could have separate schools. But what the Supreme Court did in Brown v. Board of Education is that it went back and said, was Plessy v. Ferguson decided the right way? And the Supreme Court in Brown v. Board of Education said, no, Plessy v. Ferguson was not decided. That separate but equal is discrimination. It's a violation of equal protection. And Brown v. Board of Education is going to overrule Plessy v. Ferguson. And that's what the Supreme Court did here in the Dobbs case. It went back and looked at Casey and looked at Roe and said, was this decided the right way? And it said, no, Roe was never decided the right way. There's no fundamental right to an abortion within the Constitution. And Casey should have done that back in the 90s, but it just basically said case law precedent, we're going to uphold Roe v. Wade. So this is not the first time the Supreme Court has done this, where they go back and look at an earlier decision and say, does the case law precedent apply here? Did the court, when they ruled upon Roe v. Wade, get it right? And the court said no. And the court did the same thing in Brown v. Board of Education to Plessy v. Ferguson, that the court didn't get it right. So the Supreme Court in the Dobbs case said an assessment of the strength of the grounds on which Roe was based needs to be reviewed. And said Casey, in that case, they did not even consider it. They just said, hey, Roe v. Wade applies, case law precedent. Casey is going to, our Planned Parenthood is going to win the case. So when the Supreme Court in the Dobbs case looked back at Roe v. Wade, it basically said, okay, Roe says there's an abortion right as part of the right to privacy that comes from the 1st, 4th, 5th, 9th, and 14th Amendment. As we know, there is no specific listing of the right to privacy in the Constitution. Nowhere is it written that individuals have a right to privacy. It's inferred within the 4th Amendment with search and seizure must be based upon probable cause or it's an illegal search. Therefore, we can infer that individuals have a right to privacy. The First Amendment gives a right to privacy with free speech, that you can speak words that you want to, as long as it doesn't incite violence or imminent harm, but you can also refrain from speaking. You can keep your thoughts to yourself. Therefore, it's inferred there's a right to privacy. And the Fifth Amendment, with the self-incrimination clause, says that no one can force you to testify against yourself. That could lead to criminal charges. Therefore, you have a right to remain silent and a right to privacy. But the Supreme Court said a right to privacy doesn't extend to a woman's right to choose, and it should go back to the states to decide. Casey basically, when Casey upheld Roe v. Wade, the theory in Casey was that abortion is part of a liberty interest protected by the 14th Amendment's due process clause. And the court looked and said, a regulation of abortion is not a sex-based classification, and therefore it's not subject to heightened scrutiny that applies to such classifications. And I'll get to that in a second. So when the Supreme Court reviews whether a specific law put in place or a specific law is being analyzed, whether it may be struck down, it's going to look at whether there's some kind of fundamental right. Because if there's a fundamental right involved, there's a heightened scrutiny when the Supreme Court reviews. If there's not a fundamental right, then the Supreme Court's review comes lower and it becomes a rational review, a rational basis. So it's strict scrutiny for a heightened review by the Supreme Court because the fundamental rights involved, an intermediate scrutiny when it falls in between, and rational review, which is the lowest form of scrutiny the Supreme Court applies. Supreme Court in Dobbs said abortion is governed by the same standard of review as other health and safety measures. And then the court looked at whether the right to an abortion is an essential component of ordered liberty. Let me just see if there's questions. And if anybody has questions, feel free to come off mute or feel free to type in the chat area if you have any questions. So like I was just saying, there's 3 levels of scrutiny: strict scrutiny, intermediate scrutiny, and the rational basis review. As I was saying, the level of scrutiny that's applied is really how a court will go about analyzing its effect of the law, who has the burden of proof, and what the tests are for the government or for the one challenging the law. So strict scrutiny. Any fundamental right that's involved is where the Supreme Court is going to use strict scrutiny. Any legislation or law that discriminates based upon race, national origin, religion, alienage has to pass the strict scrutiny test. The Dobbs or Roe v. Wade never made it to strict scrutiny. If it did, Roe v. Wade may still be good law today. Strict scrutiny requires that the government has to show there's a compelling state interest and that the law is narrowly tailored to achieve its result. It can't be a broad law. It can't be a law that's vague. It's got to be narrowly tailored to specifically deal with this situation. So the Dobbs case gave it back to the states, saying it's an elected official decision. You know, you the people vote for who you want to represent you, and that's what you do, and that's how you decide whether a woman has a right to choose in your particular state. So the Roe case never made it to a strict scrutiny review. Intermediate scrutiny, if Roe is to be upheld, it has to serve an important government objective, and it has to be substantially related to achieving the objective. Now, the tests are not automatically set in stone, but because the first thing is, well, what does substantially related mean? And how do you know if it's an important government objective? Courts are going to interpret that differently. But the Supreme Court in 1976 said intermediate scrutiny can be used if the law discriminates based on gender or sex. And the burden of proof in intermediate scrutiny is within the government. The government has the burden of proof with intermediate scrutiny. Here's where the Roe case came down. It was more of a rational basis review. I think they even went in between intermediate scrutiny and rational basis. And I don't know what that standard is, because they never said, but a rational basis review is the lowest level of scrutiny, and the person challenging the law must prove that the government has no legitimate interest in the law, and there's no reasonable rational link between that interest and the challenged law. And that's what the Supreme Court was saying, that the government has no legitimate interest. Here, it's more of a state government. Give it back to the states. Don't give it to the Supreme Court, because let the Congress legislates, right? Congress writes the law. Don't give the Supreme Court the power to start determining where a right to privacy falls. It's more judicial activism and legislating from the bench if you allow the Supreme Court to do that. Let me see. I see Karen has a comment. The fact we cannot completely separate the interest of the parties. For lack of a better term, a fetus is essentially a parasitic life form. It exists at the expense of the woman. So just looking at the preamble and the concept of liberty, it would seem that an individual has the right to be free of a parasitic life form. Yeah, I mean, it's a good argument, Karen. No doubt. And I think what the Supreme Court was saying is that we're just going to, and the Supreme Court might not even be disagreeing with you. They may be just saying, hey, if you want to have that right to choose, it's up to the state. Get the Supreme Court out of it. So I know there's more conservatives on the Supreme Court than liberals at this time, and who knows, if this ever gets challenged again and you get a majority of liberals on the Supreme Court, maybe Roe v. Wade comes back into place again. Well, in the Dobbs case, yeah, Karen, were you going to make a point?
I was going to say, yeah, also.
Let me turn you up. Hold on one second.
Sure. That Roe was not originally decided on the concept of liberty.
That this case wasn't decided on the concept of liberty?
Right. So, I mean, it couldn't be overturned on that basis because they used substantial due process and the right to privacy. And so, they may reintroduce it under the concept of liberty, perhaps. I don't know.
Right.
Oh, right. I brought you something also. Can you see what
Thank you. That's fantastic.
And they're huge.
That is fantastic. You can throw them after the presentation. I love it.
They're like 90 calories each.
I would love one right now. It'd be hard to talk, but I would love one. So
yeah,
that's great. So the rational basis test is basically a applies to laws or regulations that are irrational or arbitrary. I don't know if Roe v. Wade was irrational or arbitrary. What I think it was, and what I think both these cases are, is judicial activism. It's in a sense legislating from the bench. And I'm not saying Roe v. Wade was decided correctly or Dobbs was decided correctly. You know, that's not my role here. But what I will say is that you're getting Supreme Court justices who are interpreting the Constitution in different ways. And as justices change, so does the view of what our Constitution is. No, did I just hang up?
We can
It's okay.
You can still hear me?
I can hear you. Yes.
Oh, okay, good.
Yeah.
Okay, I'll turn up a little more. So Dobbs basically here is talking about substantive rights. And basically rights that are deemed fundamental, like the right to privacy, but are not mentioned anywhere in the Constitution. And that's getting to what, you know, Karen was saying, whether the right to choose is essential in a nation's scheme of ordered liberty. The court here went on to say that just looking at the term liberty, what does liberty mean? The court looked at historical inquiries, because liberty, obviously, liberty is a big word for Americans. You know, what does it mean to have liberty? And what is, in a sense, freedom? Freedom of choice, freedom of association, freedom of having due process protections. So the court looked back and looked at the history at the time of which liberty was used and inferred within the Constitution. As the court looked at what the history was revolving around abortion at the time of its ruling in Roe, the Supreme Court here said that Roe misstated history or basically ignored history, and whether women had a liberty interest in the right to an abortion. Roe and Casey both said the abortion right is an integral part of a broader entrenched right. And basically saying a woman has a right to privacy. You keep the government out of a woman's body. And that Roe v. Wade said that liberty, a woman's liberty, gives her the choice to make those intimate and personal choices that are central to personal dignity and autonomy. So Roe and Casey looked at it in the sense of balancing the interests of a woman who wants an abortion and the interest of what is considered a potential life. And that's why Roe came down and ruled the way it did. However, the Supreme Court 49 years later says the court in Roe v. Wade got it wrong. They shouldn't have decided this right to privacy. They're not saying that a woman doesn't have a right to privacy. I don't even think the Supreme Court, in a sense, is saying from their opinion that they put out here, they don't say whether a woman has a right to privacy to an abortion or not. They're saying give it back to the states. Let the states decide, because a right to privacy has nothing to do in the Constitution with an abortion. It has to do with speech, it has to do with searches, and it has to do with seizures. But it doesn't have to do anything with an abortion. That is a state issue. And that's what I think the Supreme Court is saying here. Attempts to justify abortion through appeals to a broader right to autonomy and to define one's concept of existence prove too much. Those criteria at a high level of generality could license fundamental rights to illicit drug use, prostitution, and the like. So what the court is saying there is that if we uphold Roe and give a woman a right to privacy, saying that the right to have an abortion is a privacy right, then the court is sooner or later going to have to expand that one doing drugs in one's home is a privacy right. Illegal drugs, right? Or if one wants to engage in prostitution, that's a right to privacy as well. So the Supreme Court is saying if we uphold Roe and say abortion is a privacy right, then we've got to say illicit drug use is a privacy right, prostitution is a privacy right, and where else are we going to go in the future? So the court said, we're not going to legislate from the bench. That's what Roe v. Wade did. This is a state issue. This is dealing more with, in a sense, science or medicine. The Supreme Court justices are not doctors. So we can't tell you when life begins, when a fetus can survive outside the womb. Those are where you go to your elected officials and vote for the individual who supports where you come down on a right to choose or not. Okay, let me jump ahead. Anybody have any questions on the Dobbs case before I go to like the future of Roe v. Wade or the future of Dobbs v. Jackson? Okay, I don't see anything in the chat area, so I will carry on. So when does the Supreme Court overrule case law precedent? First thing it's going to look at is the nature of the court's error. And that's what happened in Plessy v. Ferguson. That Plessy v. Ferguson, the separate but equal doctrine, was wrong because even though the cars were separate, the African Americans were getting the low end of the deal because the cars were being upkept for the Caucasians, but not for the African Americans. Plessy v. Ferguson is wrong. And that's what they said in Roe. Roe was basically, they called it on a collision course with the Constitution from the day it was decided. So they're going to look at the court's error. They're going to look at the quality of the reasoning. How did the Supreme Court in Roe v. Wade justify its ruling? What the Supreme Court in the Dobbs case said, that there's no grounding in the constitutional text or history that Roe basically imposed on the entire country and put out a set of rules for pregnancy, talking about these trimesters, which is more of a statute or regulation. You know, the first trimester or the last trimester. These are kind of what regulations do. And this is another reason why it's more of a state issue. And also, when did Roe actually justify what a potential life is, right? That the Supreme Court is kind of dabbling in an area where it should not be dabbling. And that Roe basically is law, it's legislation. And that is a violation of the separation of powers, that legislative acts go to the legislative branch. It's done by Congress. Number 3, they'll look at workability. Whether Roe v. Wade is a workable case, whether it can be understood and it can be applied in a consistent and predictable manner. I mean, we've seen states battle Roe v. Wade since it was first decided, right? Because you've got, Texas has laws in place, Mississippi, other states that basically totally restrict abortion. So that's what the court meant, that Roe was on a collision course with the Constitution from the day it was decided, that states were going to try and do, those that wanted to prohibit abortion were going to do everything they could or can do to make it extremely difficult for a woman to obtain an abortion. So workability, whether Roe was workable, I'll leave that up to you, but I will say states that are against a woman's right to choose put in legislation to make it difficult for women to obtain an abortion, keeping in mind the Roe v. Wade ruling. And you could look at all the states that had trigger laws that as soon as Roe v. Wade was overturned, these trigger laws went right into effect. Again, showing whether Roe v. Wade was workable. Number 4, it looks on effects on other areas of law. So Roe is obviously was a very cited case, used in a lot of privacy cases, that women in Roe v. Wade have a right to privacy, and therefore this case should be decided under Roe v. Wade and a right to privacy. So the Supreme Court said that Roe and Casey basically led to the distortion of many important but unrelated legal doctrines, that Roe v. Wade was being used in parts of the law and in cases where it should not be used. And number 5, it'll look at reliance interests. Overruling Roe and Casey are not going to upend concrete reliance interests like those that are involved with property and contract rights. So, like Roe v. Wade being overruled are not going to affect contract law, and it's not going to affect property law. It's basically going to just go back to the states, and the states are going to decide whether that state allows for an abortion or whether that state does not, or whether that state will only allow for abortion to a certain extent. And the Supreme Court has always been reluctant about inferring rights that are not specifically listed in the Constitution. I will pause for a minute to see if anybody has any questions.
Yes, Mr. Birmingham. I was going to ask, the original Roe v. Wade case was decided with a 7-2 majority. And although some people don't like substantive due process, it's not necessarily wrong to use substantial due process. So I'm kind of puzzled because the decision to overturn Roe versus Wade was decided by, I think it was a 6-3 margin. And
Yep.
so, I'm kind of thinking the first time Roe was decided, there were 7 judges who felt like the reasoning was sound and only 2 that felt like it wasn't. No, I just wanted to comment. I didn't really have a question per se.
Yeah, no, it's a good point to make. And I think what you look at is that when you have a liberal majority, you're going to get rulings that go one way. And when you get the conservative majority, you're going to get rulings that go the other way. And I think that's what it is. And substantive due process, there are fundamental rights within substantive due process. Justice Scalia is not a fan of substantive due process. But, you know, it's also the way you look at the Constitution. Are you an originalist and say the Constitution only means what the founding fathers meant it to mean at the time they wrote the Constitution? Or do you look at the Constitution as more as a living, breathing document that evolves with the times? They're different theories, and I'm not saying either theory is right or wrong, but that's where you get substantive due process, that there are certain fundamental rights inferred in the Constitution, even though they weren't specifically listed. And the right to privacy is a substantive due process right. Whether that right to privacy extends to a woman's right to choose, again, we could sit here and discuss and debate it all day. But if their Supreme Court a few years back said there was a substantive right for homosexuals to marry, that is a fundamental right. Whether a woman's right to choose is a fundamental right. I mean, I get both sides. That's why I'm doing this lecture, because I can't make up my darn mind. I don't know. But with both courts, the Roe v. Wade court and the Dobbs court, both in a sense committed judicial activism. And judicial activism is decision making where judges allow their personal views about public policy to help guide their decision, right? Because by the Dobbs case saying this should go back to the states, there's nothing in the Constitution that says the Supreme Court has to decide whether Roe v. Wade is good law or bad law. It's basically the judges saying, is this a state issue or is there a fundamental right to privacy? Constitution doesn't guide them either way. I don't think. I think it's the court saying it's not specifically listed, so we'll give it back to the states. But if you go as the 7-2 majority in Roe v. Wade, yes, women have a fundamental right to privacy. Men have a fundamental right to privacy. Within a woman's right to privacy is her body, and government has to stay out of it. And it's a sound argument. I mean, there's no doubt that both, you know, I could say Roe v. Wade was decided correctly and the Dobbs case was decided correctly. I mean, that's kind of the easy way out, isn't it? Maybe I'll get that marshmallow thrown at me. But it's, you know, I mean, it's hard to decide because it's really me now jumping in and saying, here's my policy on how to guide my decision.
Exactly. One of the things that I find the most troubling, though, is that, you know, each individual case is an individual case, and even having that decided by a state, to me, seems it still seems a little bit like it's interference in a personal decision, you know, even if it's the state, like say Texas, that has a trigger law, etc. You know, so I don't think we've completely put the issue to rest yet, you know.
Yeah. So. Yeah, I don't think so either. I don't, and I'll talk about where the future might be headed in a few more slides, but that's what judicial activism is. It's basically judges using personal views to help guide their decisions. And, you know, the last sentence here, even when there is case law to guide the judge, right, or the justices, which Roe v. Wade was case law, a judge can still use judicial activism if the case calls for it. And in the Dobbs case, they're saying, yeah, it's called for because they got Roe v. Wade completely wrong. And judicial activism is used, the act of overturning laws as unconstitutional, overruling judicial precedent, ruling contrary to a previously issued constitutional interpretation. And that's what they did here. That's what the Dobbs case did. Both Roe v. Wade and Dobbs are judicial activism. Brown v. Board was judicial activism, right? Because Plessy v. Ferguson was the case law precedent. Supreme Court reviewed it and said, no, if Plessy v. Ferguson is not working out, it's not part of the workability, it's violating that element of when the Supreme Court needs to overturn a case because African Americans are still being discriminated against. Let me jump ahead here. But that's what judicial activism is. It's when you hear the term legislating from the bench, that's exactly what the Supreme Court is doing. And they're telling you how the Constitution should be interpreted. You know, whether it's conservative or whether it's liberal, conservative and liberals have different views of the Constitution and how the Constitution should be read, whether it's a dead document or whether it's a living and breathing document. And it gets to the question, do judges really follow the law? Because there are negatives and positives to judicial activism, right? Because you can get a court that says, oh, the right to privacy, well, that now includes illicit drug use, prostitution, other bad acts, but you got that right to privacy. The positives can be, well, homosexuals now have a right to marry. And yeah, I mean, you can say there's positives and negatives, right? Because you're allowing a court to interpret the Constitution as they see fit. So courts do make public policy. I have no doubt of that. The Warren Court did it during their years in the 60s to deal with social reform, to protect individuals from police overreaching. So I definitely believe that courts make public policy in their rulings. You know, they want to shape a stop and frisk. What is stop and frisk? Well, it's an outside pat down of the body to make sure there's no dangerous weapons in an individual's pocket or something that could harm a police officer. But they can only do it in certain instances. Otherwise, you're going to get police interfering with an individual's freedom or right to move. And so courts do it. And I think they also did it. They definitely did it with gay marriage. Their gay marriage was, I kind of call it like an even split. Many were in favor of gay marriage. There were also many who were against gay marriage as being recognized under the Constitution. But the Supreme Court in that case said, well, there's a due process right, and substantive due process says there's fundamental rights, even if not listed in the Constitution, are solely reserved in certain areas like the right to marry. That's making public policy in a sense, right? Because you're giving homosexuals the same rights as a heterosexual couple. So that's public policy, because there's nothing in the Constitution that says homosexuals have a right to marry, or that marriage is solely reserved to heterosexual couples. There's nothing in there. You're leaving it in the hands of the Supreme Court. And it gets to the important point that I always tell my students: when you're looking to vote for president, a big factor to consider is knowing that president is going to appoint the next Supreme Court justices. So keep that in mind. You want to look at the president, for whatever reason on who you vote for president. But one of the things to consider is that if you vote for this individual for president, you may get conservatives on the Supreme Court. But if you vote for this person, you may get liberals on the Supreme Court. And where do you want the direction of the Supreme Court to go? So the future, is there a question?
Just one last one. I promise I won't bother you anymore.
You're not bothering me. Ask away.
Okay, I was going to ask you. So I felt like it was very unfair for Obama's last Supreme Court nominee not to be interviewed or not to be considered for like a whole year. That just doesn't really seem right to me, that for a whole year of his last, term of presidency, McConnell and others decided, just basically stonewalled him and didn't allow his nominee to be considered. And I just kind of wanted to get your thoughts on that.
Welcome to politics. Hey, I'm with local government here in my town, and I'm a supervisor here in town. I deal with that garbage all the time, and I'm not saying I'm for or against Obama, but that's politics, and yeah, it's frustrating, and it's frustrating, yeah, but Democrats do it, Republicans do it, libertarians do it, independents do it. It's all about politics, and whether they need to. You could put a law in place or put something in place that when the president nominates someone for Supreme Court justice, the Congress has to respond in so many days. You can always put a law in place to do that, but do you want to do that? Because if the Republicans are doing it to Obama's nominee, Democrats may do it to the Republican president nominee. So it's like almost the impeachment. Well, you impeached Trump, so now we're going to go impeach Biden, and it's politics, and that's why politics gets a bad name. But just talking about the future of Roe v. Wade, and I'll leave some time for questions at the end. But President Biden and Democrats, after the Dobbs case came down, have talked about putting a federal law in place. That's one way that the Dobbs case could be overruled. Put a federal law in place, right? Because Roe v. Wade was a Supreme Court case, and we know Supreme Court rulings are binding throughout the United States. But you know what? So is a federal law, right? And they tried it with the Women's Health Protection Act, but didn't get enough votes to pass. And but is there another federal law coming down the line? I'm sure those who are against the Dobbs decision are talking about it. Yeah, and right now they don't have the votes to get where they want to go if they wanted to make Roe v. Wade federal law. And they could do that, right? They could do it. And all you have to, did I just lose my PowerPoint? And all you have to do is make sure that it doesn't get struck down by the Dobbs case. So you'd have to very carefully craft the federal law and make sure that it doesn't interfere with Dobbs in any such manner. But it can be done. And that's where we're getting at. We're looking at the power of the separation of powers. Who's more powerful? Is it the legislative branch, the executive branch, or the judicial branch? And you could say the judicial branch, because it interprets the Constitution and tells you what laws are constitutional and what laws are not. But Congress has ways in which it can override the Supreme Court. Another way they can do it is just override with the 2/3 vote, right? Amend the Constitution, specifically list in the Constitution that women have a right to abortion up to viability. They could put that in place, and that would override the Dobbs case. So they can do it that way. They can also change the number of justices, right? So we have 9 now. And Biden was always asked about this, President Biden. What if you increase the Supreme Court by 14 and Biden nominates 5 liberal justices? Then you've got the majority going to the liberal way, and maybe Dobbs gets struck down, right? So that's another way to do it. Let me see if there's any comments in here. Okay, Michelle, just makes it more obvious that the Supreme Court should not be for life, or if it is, should be split evenly. Yeah, no, it's a good point. I mean, yeah, you got justices who are writing opinions in their 90s and may have been on the Supreme Court since they were in their 50s, right? So, yeah, I mean, and I'm all for term limits as well, you know, with Congress. So, yeah, it's I totally agree. I think oh, did I just, am I still here? Let me
Yes.
see.
Yes, you are. You are.
Okay, I don't know what happened. Where's my, let me find my PowerPoint. Can you, oh, there I am. Okay, sorry. I got confused there. Okay, so and you have these slides, right? Okay, so you know, just the ending cases here is just talking about Roe v. Wade, Griswold v. Connecticut. These are right to privacy cases. Bowers v. Hardwick. Again, you know, we're looking at the right to privacy, and actually, where does the right to privacy expand to? And here's the Supreme Court expanding it in certain areas. Lawrence v. Texas. So the bottom line is the right to privacy is a fundamental right. I think the Supreme Court would agree with that. We've got too many Supreme Court cases that deal with the right to privacy. And the toughest thing is, where does that right to privacy extend to? And the Supreme Court in the Dobbs case said that at the time of the ruling of Roe v. Wade, the right to privacy should not have extended to a woman's right to choose. That the Supreme Court got it wrong, in the sense that they went too far with substantive due process, and they got it wrong. And it should be a state issue. Yeah, there were many who said homosexual marriage should be a state issue. Not that you're for or against it, but let the states decide. I mean, that's what the 10th Amendment is all about. If it's not specifically listed in the Constitution as Congress having that right, or saying the states can't do it, the 10th Amendment says the states can do it. And that's where they came with this Dobbs ruling. Not saying that women don't have a right to privacy and a right to choose, but the states need to decide it, not the Supreme Court, and not this judicial activism asking us to read into the Constitution something we don't want to read into. I'm not saying the Dobbs case is right or wrong. That's what I'm just telling you how the Dobbs case came down. So I will leave it open for questions, but again, thank you for having me back. My 1 hour presentation was a 2 hour presentation, and that's my phone number. You can call me anytime if you have questions or you want to talk about the Dobbs case or any Supreme Court cases. I'm happy to talk about, I'll set up a Zoom meeting. I'm happy to do it anytime. That's my email address. I got to be cool and get rid of the AOL, but hey, I'm old and dorky that way. So what are you going to do? And then I'm on LinkedIn and Facebook. I only have one friend on Facebook, so I welcome friends if you want to stay in touch that way, or connect with me on LinkedIn, and I'm happy to connect that way. So thank you again. I'll be back, I think, in November. I don't know the date offhand, but I'm doing a presentation on ethics and the law, and I'll see you next month. Until then, everybody have a great day.
Thank you so much.
Thank you, Karen. You can throw the marshmallows now if you want.
Thank you so much, Mr. Birmingham.
Okay, thanks, everyone.
The next presentation by Mr. Birmingham is on November 10th. So please be sure to go to the website, dallasparalegals.org, to register for that presentation.
And I didn't miss any questions, right?
No, you did not. No,
okay.
You were right on point. Everyone saying thank you. Great presentation. Very informative.
Oh, thanks.
Yes. If you need credit for this presentation, I did post a passcode in the chat. So feel free to give me an email. Matter of fact, I'm receiving them now.
All right.
Hey, John, how are you?
I'm sorry, who said hi?
This is Melody.
Hey, Melody, how are you?
I'm doing good. I just wanted to say hello. I've been working behind the scene, but I see you, and I'm so glad that you came to present to us from all the way from Philadelphia, right?
Yeah, I live in Mount Bethel, Pennsylvania, about an hour and a half from Philly.
Right. So I met you at the Paralegal Conference for NALA.
Yeah, I remember.
Okay.
Yeah, you were great, and it was a pleasure meeting you, and thanks for bringing me here.
Oh, you're very welcome. You're very welcome. The presentation was really good, and I couldn't wait to email you so that you can come and present for us in DAPA. You were honored today because you have the paralegal, the president of the State Bar Paralegal Association
was here.
On here.
Oh, awesome. Thank you so much.
You have big fans at DAPA.
Thank you. Well, I'll be back in November, and you know, I'll keep coming back if you'll keep having me, and yeah, we'll stay in touch.
Yes, and if you have anything else that you're interested in presenting to us, please let us know, because we'll be happy to have you. We have CLEs every month by Zoom. So if you have something else that's burning that you want to talk about, please let us know, and you are welcome to come and say, hey, I have this date available. What you think? We said we got to do it.
I'll do it.
All right. Thank you so much.
And thanks for working with Elena.
Okay, thank you.
Thank you.
Your plug there. Bye-bye.
Have a good day. Thank you, everyone.
Good day. You too.
Thank you, everyone. Y'all have a good day.
Bye-bye.
Bye.
Is it just us? Oh, they did.
There we go.